Good morning, and thank you for joining us for today's Employment Law Basics for Small Businesses with presenter Christina Tamaino. This third part of the series is titled Best Practices for Ending Employment Relationships. This program series is a partnership between the Barry Public Library and the Small Business Center. In this month's Learning Lab, key issues regarding termination from employment, including strategies and best practices for limiting liability, will be discussed. My name is Modupe, and I'm from the Barry Public Library. And I would also like to introduce my colleague, Caitlin, from the Small Business Center. She will be taking care of the tech and questions in the chat window. The presenter will take questions in the chat during the presentation, so you can put them in at any time during the presentation. I'd like to introduce and welcome our presenter, Christina Tamaino. Christina is a labor and employment lawyer practicing at SV Law. Christina advises on a broad scope of labor, employment, and human rights issues, including employment standards, grievance arbitration, collective bargaining, and workplace accommodation. She provides strategic guidance in navigating complex workplace issues and implementing sound workplace policies. Christina is also an experienced workplace investigator and regularly assists both unionized and non-unionized employers in responding to allegations of workplace harassment, violence, and discrimination. I will now hand it over to you, Christina.
Thank you so much for the kind introduction and for having me in again today. I'm very excited to be back with the Small Business Center for the third part of our Employment Law Basics for Small Businesses series. I know a lot of the questions that employers, and particularly small employers, have around the employment relationship occur at this stage when it's time for termination. Something's gone wrong for whatever reason, and we're looking to end the relationship. So today we'll be going through some of the foundational principles that exist around termination of employment in Ontario and some of the common hiccups where employers may invite unnecessary liability. So I'll just take us through the agenda first. As I said, we'll touch on some key issues, and it's important to remember that this is a high-level overview of the issues. Ultimately, when it comes to employment law, everything is assessed on a case-by-case, fact-specific analysis. So each situation will need to be addressed on an individualized basis, but my hope is by giving you some of the tools and the knowledge to identify some of the key issues in terminations that you as an employer will be able to navigate them successfully. So we'll start today with just understanding and identifying the various termination entitlements that an employee in Ontario may have. Then we will turn to the statutory termination entitlements in more detail. So that is anything governed by the Employment Standards Act. Then we'll discuss common law reasonable notice, which is the more concerning branch of termination entitlements for most employers. And then we'll touch on just cause termination, as well as strategies for mitigating risk. And as stated earlier, I am, of course, willing to take questions as we go, but we'll also have some time at the end for questions and discussions for anything that comes up during the presentation. So when it comes to employment law in Ontario, there are I'll call three branches of termination entitlements. So the first is statutory notice of termination, or termination pay. This is the one that most employers are quite familiar with. So roughly speaking, it works out to, I would say, a week per year of service, up to a maximum of 8 weeks. So this is often where employers start and sometimes stop when they're thinking about termination entitlements. So they say, oh, someone's been with me for 2 years. I gave them 2 weeks. I'm done. That's all my liability covered. And unfortunately, that's often not the case. Now, the second branch is statutory severance pay, which is a separate entitlement to termination pay. That is triggered at quite a high payroll threshold. So for most of our audience today, I expect we will not need to be concerned with statutory severance pay. But we will still go over it in some detail, because things change, businesses grow, and at some point it may become a valid consideration for many of the small businesses joining us today. And then the third is common law reasonable notice. So this is the big one when it comes to liability. If you've seen any of my employment law colleagues on, say, CB24 advertising that, oh, if you've been terminated, you may be entitled to, say, 2 years pay, that's the common law reasonable notice. So we'll spend quite a lot of time there today. Right. So when it comes to statutory termination entitlements, the piece of legislation that we are concerned with is called the Employment Standards Act. And if you joined us for either of our first two Learning Lab series on employment law basics, we went through the ESA in some detail. So certainly do go check those recordings out if you have some time. But the ESA outlines the minimum entitlements owed to employees in many respects, including termination from employment. So the ESA will outline the minimum period of notice that must be provided to an employee in the event of termination, assuming that they've been continuously employed for a period of 3 months. Now, notice of termination or termination pay are permissible for this branch of termination entitlement. So what that means is, as an employer, you can tell someone your ESA termination entitlements are 2 weeks. We'd like you to work out 2 weeks, and at the end of that period, our employment relationship is severed. Or you can provide 2 weeks pay in lieu of notice, which is the route many employers go to. So not every entitlement can be provided as either notice or pay in lieu of notice. So it's important to be mindful of the specifics for each entitlement as you are proceeding with your terminations. And so this slide may be familiar if you joined us for our earlier two presentations. So this outlines the statutory notice of termination periods outlined in the Employment Standards Act. So as you'll see, the period of employment, as that increases, the notice requirement or pay in lieu of notice requirement increases as well. So up to that threshold of 8 weeks. So as your first step, when you're considering a termination, I would reference this chart. It's available in one of my earlier presentations. I linked to what's called the Guide to the Employment Standards Act. There's some great resources online that can provide some guidance there. So as a very first step is looking at the Employment Standards Act, establishing those minimum entitlements and making sure that you're compliant. Now, during the statutory notice period, there are a number of things that need to be considered because missteps in this time frame can lead to an award of damages against an employer. So an employer cannot reduce an employee's wage rate, any terms and conditions of their employment, discontinue benefits, or any other perks that an employee may be entitled to as part of their total compensation package. That will all need to be continued through the statutory notice period. What I often see is employers will say, well, I'll give you 2 weeks notice, but we actually don't need you in the office. So go home and we'll be done. That can work if it's a salaried employee, but if it's an hourly employee, then what you've really done is you've reduced their earnings for that notice period in a way that is impermissible. So my rule of thumb is, if in doubt, just stick to the status quo during the statutory notice period. And that is the case regardless of whether you are providing notice of termination or pay in lieu of notice. So if you are providing pay in lieu of notice, you'll need to ensure that every aspect of an employee's termination employee's compensation package is reflected in the termination pay. Now, the next element of termination entitlements is what tends to trip employers up, and that's statutory severance pay. So severance pay is completely separate from termination pay and from notice of termination. It is an entitlement only for certain long service employees, and it's intended to compensate them for the losses that follow the loss of a long-term employment relationship. So things like seniority and the various perks and benefits that go along with that. So severance pay, as discussed, is only owing to certain employees, and we'll go through the eligibility test in just a moment. But for both termination and severance pay, the employee must receive those payments either 7 days after their employment has ended or on what would have been their next regular payday, whichever is later. Now, severance pay cannot be provided as notice. So if an employee is entitled to 2 weeks or 5 weeks of severance pay, you are required to pay out that amount. You cannot simply tack on some notice if you're providing working notice. And now the reason I said most of our audience won't need to be overly concerned with statutory severance pay is that an employee will only qualify if they have worked for their employer for a period of 5 or more years, and their employer has a global payroll of at least $2.5 million. So that's changed recently. It used to be 2.5 million in Ontario, but there's been some case law that says it's now global payroll. So I appreciate that for most of us in this room, this will not apply, but it's important to be mindful that this entitlement exists. Because when you are formulating, say, your employment contracts, you will need to reference that there may be an entitlement to statutory severance pay. And we discussed that to some extent in our last learning lab. Now, to calculate the amount of severance pay, it's the number of completed years of employment and the number of completed months divided by 12. So the maximum is 26 weeks, and that's in addition to any ESA termination pay or notice of termination that may be owing. This is where things get a bit math heavy, so I do recommend there's some good tools online that I believe it's the Ministry of Labor has put out. They've got a great severance pay calculator, which I tend to use as opposed to pulling out my own calculator and trying to do the numbers, but certainly something to be mindful of as the entitlement to statutory severance pay can be quite high. All right, and I'll just take a quick glance at the chat to see if we've got any. All right, perfect. So moving on to what I'll say is the most significant element of termination entitlements for employees, and that's common law reasonable notice. So common law refers to judge-made law, and wrongful dismissal damages at common law can be quite significant. So absent an enforceable employment contract, employees are presumptively entitled to common law notice of termination. This amount will be inclusive of any statutory payments. However, it is significantly higher. When calculating common law reasonable notice, courts take into consideration 4 factors. It's a very well-established analysis. They're called the Bardal factors, and they're looking at an employee's age, length of service, character of employment, and the availability of similar employment. Now, of those 4 factors, I'll say that age and length of service are far and away the most significant. So if you are a small employer and you are considering terminating an employee who is either approaching retirement age or has been with you for a lengthy period of time, I'd highly recommend that you seek some advice from either an HR professional or workplace counsel and get some guidance on that, because that can be a very costly termination. And when it comes to the exact amounts of common law reasonable notice that may be owing, it will differ from case to case. So there's no hard and fast rule. However, practically speaking, it tends to work out to 1 month per year of completed service at the high end. So as you can appreciate, that can result in quite high awards of damages, although the courts do cap it at 24 months. Now I have a sample fact scenario here that we can go through to illustrate some of the different ways that the various branches of termination entitlements come into play, and segue us into some of the mitigation strategies. So our employee here, her name's Danielle, she's 45, she's worked for her employer for 12 years at the time of her termination. Without an employment contract, Danielle is presumptively entitled to common law reasonable notice. And that range can be anywhere between, say, 10 and 12 months pay in lieu. So that's quite a significant sum, especially for a small employer. Now, with an enforceable employment contract, however, we can limit Danielle's termination entitlements to what would be provided by the Employment Standards Act. So that's the first category that we discussed. And in that case, her termination entitlements would be limited to 8 weeks notice or pay in lieu of notice. Now, if her employer, who I've dubbed Smith Inc., is a severance paying employer, that is the $2.5 million global payroll, then Danielle would also be entitled to a further 12 weeks of statutory severance pay. So as you can see from this example, the range of possible liability to an employer is quite large. So if you have some good protections in place in the form of an employment contract, good policies, good procedures, then you can mitigate some of that risk that comes from the common law reasonable notice of termination. And again, I'll direct you back to our last Learning Lab, where we went through some of the elements that ensure an enforceable employment contract. And I believe that both the Barrie Library and the Barrie Small Business Center have some resources that they typically put in the chat that provide some good employment contract templates, which can be very helpful. And I'd certainly recommend taking a look at those. All right, so I see I've got a question in the chat I'll just jump to before continuing on. It's from Teresa, and she asked, does the common law apply to small business owners with few employees? Yes, so the common law applies to all employers in Ontario. So even if you are an extremely small business, you've been in existence for 2, 3, 4, 5 years, it doesn't matter. The courts will apply the common law reasonable notice assessment. Granted, if you've only been in business for a short period of time, the liability is going to be limited just based on the timing. But that it is something that all employers need to be mindful of, regardless of the size. Even if you just have one employee, they, absent an enforceable termination agreement, they will be entitled to common law reasonable notice. And so the follow-up question there is, what constitutes an enforceable employment contract? So that changes, it seems, from month to month and year to year. The case law in this area develops extremely quickly, and the courts are very particular about the language that needs to be included in an employment contract. For my, if there's any employment law colleagues in the room, I'm sure they feel my same frustration, and the frustration that I'm sure is felt by many employers, and particularly small employers, because the courts are very unlikely to uphold termination contracts unless they are absolutely pristine with respect to the various requirements that they are looking for. So what those are is there needs to be a reference to each and every element of an employee's statutory entitlements. What that means is there needs to be a reference that they will be provided with notice of termination or pay in lieu of notice pursuant to the Employment Standards Act, severance pay if owing, benefit continuation for the notice period, regardless of whether the employee is entitled to benefits. So what I hear all the time is, I didn't mention benefits in my contract because we don't provide benefits. The courts simply don't care. All of the elements need to be listed in order for a contract to be enforceable. I'd highly recommend, if you are a small employer, it's well worth the investment to speak to either a resource like the Small Business Center or the Barrie Public Libraries, or an employment lawyer, and get some contracts drafted. What I always recommend to my clients is that I don't want you to have any legal fees related to a termination. I'd rather you take the investment that you would make in putting out the fire and invest in some good contracts, policies, and resources that will serve you over the life of your business. So certainly take a look at some of the templates that are available. Take a look at our previous Learning Lab session, but I always advise caution when it comes to drafting employment contracts. It's such a specialized area that I would recommend seeking out some guidance on that. And when it comes to contracts, another area where things get a little dicey is just cause termination. So the recent or the most recent developments in the courts around termination provisions has revolved around just cause termination and the language used in contracts in that respect. So just cause or with cause termination is essentially going to occur in situations where an employee has engaged in misconduct, where the employer is saying, there is no way to continue this employment relationship, and I feel that because of your conduct, you are not entitled to notice of termination or any of the termination entitlements provided to you at law. Now, the definition that's used in the Employment Standards Act is willful misconduct, disobedience, or willful neglect of duty that is not trivial and has not been condoned by the employer. Now, I cannot overstate that this is an extremely high bar. Truly, only the most egregious of circumstances will justify a for-cause termination. Things like theft, repeated harassment, violence in the workplace, really very, very high stakes behavior. In most cases, things like simple performance issues, incompetence, occasional absenteeism, it's just not going to be sufficient to give rise to that standard that will allow you to terminate without providing notice of termination or termination pay. So this is another area, just like with employment contracts, where I would absolutely recommend, if you're a small employer, before pulling the trigger on a for-cause termination, seek some advice, either from workplace counsel or from an HR professional, to make sure that you are not setting yourself up for a wrongful dismissal claim, as the misclassification of a termination as for cause, when at law it should have been without cause, can lead to an award of damages as well. So you want to be very careful before taking that position. And in most cases, I would say that you are likely better off to simply take a without cause position, provide termination entitlements, and wash your hands of the employee. Okay. So I'll spend some time on this slide, and that's going over some strategies for mitigating risk. So the fact of the matter is that a termination from employment is always going to have some level of risk associated with it. And what we can do as employers and small businesses is make sure that before we take that step and proceed with a termination, that we've taken every precaution possible to limit that liability that may result. And as I've discussed to some extent, part of that mitigation strategy starts at the beginning of the employment relationship by implementing an employment contract, assessing the employee's work performance as they go. So I saw a question in the chat about termination during the 3-month probationary period. And that's a great point. So under the Employment Standards Act, if you are terminating an employee during that probationary period, there is no entitlement to termination pay. So I hear from employers all the time, oh, well, I saw issues during the probationary period and I didn't act on them. And now we're, say, 6 months in and I'd really like to terminate. Well, now there is an obligation to provide that notice or pay in lieu of notice. I often am asked about extended probationary periods. So for example, I've seen contracts that say the first 6 months, 8 months, year of employment constitutes a probationary period. And that is doable to an extent. However, it's important to be aware that at that 3-month mark, under the Employment Standards Act, obligations kick in with respect to termination pay or notice of termination, and simply having a contractual probationary period that extends that 3 months will not be sufficient to defeat those entitlements. So that's something to be mindful of. And as we discussed in last month's Learning Lab on navigating issues that come up in the employment relationship, it is crucial to ensure that you have detailed, documented, and dated documentation at every stage of the employment relationship. So if there are circumstances where you feel an employee is struggling and there are performance issues, before terminating that employee, try performance management. Give a written warning and give some clear steps for improvement. And that's the case with other areas of, say, behavioral misconduct as well. If someone is communicating inappropriately with colleagues or with clients, having those discussions and giving that opportunity for improvement before jumping to termination can help mitigate some of those risks. And of course, as I said at the start, it will be dependent on the fact scenario. So if sometimes you just need to end the employment relationship, and that's absolutely fine. But if you have those well-documented progressive steps on hand, that will put you in a far better position to defend any wrongful dismissal claim that may come in. The other piece I'll say is before proceeding with a termination, it is critical to consider any complicating factors that may arise. For example, the engagement of the Human Rights Code. So in Ontario, the Human Rights Code outlines a number of prohibited grounds of discrimination that, if breached in an employment context, can lead to either a human rights claim or a higher award of damages. And those are things most commonly like disability, for example. So what I'll see is an employer will come to me and say, oh, well, I terminated this employee. They needed workplace accommodation, but the reason I terminated them had nothing to do with their disability or their accommodation, but they both happened in the same month. That's going to be a high risk termination because the threshold for human rights damages is quite low. So anytime there is one of those factors, there is the engagement of a code protected ground, you really want to hit pause and reassess if termination is necessary at this time. It's not to say that you cannot proceed with a termination, but that's another one of those scenarios where I think you would be very well served as a small employer in seeking out some guidance and some individualized advice on how to best proceed. And frankly, sometimes the best thing to do is give it time, is let create a break between the protected ground coming to light and the termination, because that will do a lot in terms of preventing liability in that sense. The other thing to be mindful of is situations that may result in allegations of a reprisal. So if an employee has raised concerns about occupational health and safety, if they've made a claim with the Ministry of Labor, if they've brought harassment allegations forward against a colleague, a coworker, a manager, those are all situations that I'll call complicating factors that if a wrongful dismissal claim does arise, the employer will need to respond to and will need to be able to establish that those factors had nothing to do with the termination. And like I said, it's a low bar. So absolutely something that would trigger me as counsel to say, proceed with caution. At the time of termination, a very helpful tool for employers, which they often don't like considering, is providing an enhanced severance package. So say, for example, we go back to our fact scenario with Danielle. So if she is entitled to 8 weeks under the Employment Standards Act, as an employer, I've assessed that she may be entitled to 10 or 12 months at common law. Well, what I might do in that situation is say, we have to terminate your employment. This is your entitlement under the Employment Standards Act. However, we are willing to provide you an enhanced package of, say, 4, 5, 6 months in order to assist with the transition, and critically, in exchange for a full and final release, which is a legal document that essentially says that in exchange for the enhanced severance payment, the employee is releasing the employer of any liability related to their termination from employment. So that can be extremely helpful in avoiding litigation right off the bat. And certainly it doesn't have to be as high as the 4, 5, 6 months I used in my example, but say if someone's entitled to 2 weeks under the ESA, perhaps you offer a month in exchange for that release, and that can do a lot to divert some of the liability. And of course, in the termination process itself, just be mindful of the way in which you're going about it. Bad faith in the termination process can lead to an enhanced award of damages. So really give some thought to how you're going to go about the termination. So you want to make sure the notice of termination is in writing. You want to present it privately to the employee. You want to do so in a manner that is respectful, brief. If you expect that the employee is going to be very upset by the news, I tend to recommend making arrangements to have a cab or an Uber to take them home after, if you think that's going to be a concern, and be mindful of your timing. So, don't terminate someone during the holiday season. Don't terminate someone on their birthday. Be mindful of those considerations, because it can, although minor, it can motivate an employee to seek out legal advice where they otherwise wouldn't if they felt that they were treated well during the termination process. If the employee was good at their job and it's just operational reasons that you can't keep them on, perhaps offer a reference letter right off the bat to assist in their mitigation efforts. And for you as an employer, the sooner that employee can find new employment, the better. In the event of a wrongful dismissal claim, One defense that employers have is to say that an employee has mitigated their damages. Essentially, that they found a new job, and because of that, there are no losses to the employee. So if you can provide assistance at the front end in helping that employee find new employment, absolutely. So if someone calls and says, I have an application from so-and-so, what can you tell me about them? Certainly don't. I know when relationships end badly, there can be a temptation to say, absolutely don't hire this person. I would avoid that. Certainly there's no need to be gushing, but at the very least, keep it neutral. I'm just going to take a glance at the chat. So Teresa asks, if you're selling a corporation and the new buyer wants to keep their employees, what do you do with the contracts and termination? So that's a great question. That's a fairly complicated question. It will depend on the sale agreement. So typically that is all addressed in the sale of business. But broadly speaking, and very simplified, if there's a sale of business and the employees continue with their employment, then they've mitigated their damages. There's not a break in employment, and that can be a full defense against any wrongful dismissal claims, but that will be a very fact-specific assessment. What I also often hear from employers is they'll come to me and they'll say, I have this claim here that is alleging wrongful dismissal, but I don't think I did anything wrong. I didn't say that they were terminated for cause. I didn't do anything against this employee. I just terminated their employment. And that can be a bit of a misunderstanding for some employers. Really, when there is a wrongful dismissal claim, all that's saying is that the employee believes that on termination, they should have been provided with a higher notice period or pay in lieu of notice than they received. So it in most cases is not a reflection on anything else besides the fact that the compensation provided to that employee they believe to be insufficient. Now, in the event that you do receive a wrongful dismissal claim as an employer, there's a couple things you'll want to consider. The first is making sure that you meet your deadlines. Typically, what you'll get at the outset is just a demand letter, typically from a lawyer saying, I represent this employee. I am asking that you provide them with an enhanced termination package. So I think there's a lot of value in negotiating at that stage. Ignoring it is not going to make it go away. So it is well worth your time to consider any request that's being made for negotiation, and either deal with counsel directly if they have retained counsel, or retain counsel of your own to represent you and your interests. If an employer says, I'm not playing ball, I refuse, what that's going to do is trigger a wrongful dismissal claim, and you'll receive a statement of claim, and that is a legal process, and you are required to participate. Otherwise, a decision will be made without your participation. So if you do receive a statement of claim, like I said, be mindful of your deadlines. Depending on the court, the turnaround is very quick, say 20 days, to respond to a statement of claim. So you want to be sure you're acting quickly. You want to make sure that you've gathered and maintained any and all documentation that you think you may need. So we've chatted about a number of documents that may be valuable. You want to make sure that you have those on hand and preserved. And you want to be sure that you're not letting the principled decision get in the way of the business decision. So what I often hear is employers who feel that the relationship has either ended badly and they're not interested in providing that employee with any further amounts, or they feel that they treated the employee quite fairly and that their initial termination package was generous, and they don't understand why they're now getting a wrongful dismissal complaint. In both cases, what I hear as counsel is, well, I'm not increasing my offer. I'd rather pay you than pay them. It's a principled thing. That's all well and good. But at the end of the day, the law of common law reasonable notice is extremely clear and extremely well established. And in almost all cases, there is no value in taking that principled stance. Because at the end of the day, if there is no enforceable employment contract, the employee is entitled to common law reasonable notice. And that amount is in almost all cases, it will exceed what's provided to them on termination. So there is certainly there's a time and place for a principled stance. You know, if there has been egregious misconduct, if the amount offered does approach or exceed their common law entitlements, but otherwise there's not a lot of value to it. I would say, in my experience, 95% of wrongful dismissal claims resolve out of court. And that may be a low estimate, frankly, because the law is so clear that it is extremely easy to predict what a court is going to do in that circumstance. And so the value for, or the cost for both parties, both the employee and the employer, in taking the matter to litigation is simply not there. So I just always have an open mind when it comes to negotiations, and that full and final release, if you can get it signed, is worth its weight in gold. All right, so I know there's been some questions throughout, but you can jump to any other questions or discussions. I know that was a lot to throw at you all at once. Okay. So Denise is asking if this will be sent to us and recorded. I believe, and certainly I'll let my host correct me if I'm wrong, that it is uploaded to the Small Business Center's YouTube page, I believe.
Yes, we will upload it to the Small Business Center's YouTube page.
Okay, if there are no more questions, I'd like to add to the talk that you can borrow books on employment law, and on managing employees from the Barry Public Library. You can also download free employment contracts and human resource legal forms from Law Depot. I have shared the link to both our business databases and Law Depot in the chat window. The next Learning Lab is on Wednesday, May 18, and it is on networking for small businesses. I'd like to thank you, Christina, for sharing your expertise with us on this topic today. A recording of today's session, like Christina said, will be available on Small Business Center's YouTube page in the coming weeks. Thank you, SBC, for co-hosting with the Barry Public Library. And please remember to complete our feedback form in the chat and let us know how we did today and what programs you would like to see in the future. Thank you, everyone, and have a good day.
Thank you so much.
Thank you.